Are you facing a divorce and are afraid you'll become a weekend parent? That one day you'll wake up in a quiet house and realize you barely see your kids anymore? If that fear has kept you up at night, you're not alone and you're not powerless. But here's what's wild. Florida doesn't start from the idea that one parent wins and the other loses. They start with 50-50 in mind. In this video, I'll show you what Florida courts actually look for and give you 5 practical steps you can use to protect your time and your relationship with your child. I'm Annette Sanchez, a Florida family law attorney, guardian ad litem that advocates for children's best interests in court, and former attorney for the Department of Children and Families. I help parents design child-first, court-ready parenting plans that keep kids stable and connected to both homes. Here's our plan for today. Step 1, myths versus Florida realities. What the actual law emphasizes. Step 2, show up and document. The simple 3-item evidence plan that proves daily parenting. Step 3, design a child-first schedule. How to anchor time sharing to school so weeks feel predictable. Step 4, protect the relationship. How to avoid interference, handle missed time, and understand relocation rules. Step 5, use clear communication and app. Messages that help you, your co-parent, and, if needed, the court. By the end, you'll know the levers that matter and have language that you can use today. But a quick note before we begin. This is general information for Florida families, based on Florida law, not legal advice for your specific case. So, let's name the big fears. I hardly see my child. I'll miss bedtime. I'll miss the small everyday things that make me a parent. That fear is human, and it can make good people either fight too hard or give up too soon. But here's a reframe to give you hope. Florida family law is child-centered. Courts look for the frequent and continuing contact with both parents whenever it's safe and practical. The decision is framed through 2 ideas. Time sharing, that's the schedule, and parental responsibility, that's major decision making. In most families, the question isn't which parent wins, it's what plan gives the child a stable, healthy relationship with both parents. Here's a quick self-check. Can your child tell you right now where they'll sleep tomorrow night? If yes, you're already ahead. 2 signals tell you you're on the right track. First, your proposed schedule is predictable, especially when mapped to school. Second, the messages facilitate, rather than frustrate, your child's relationship with the other home. Let's begin by busting the biggest myths so that you can move from fear to a plan. Step 1, myths versus Florida realities. The myth says courts automatically favor one parent and the other parent gets scraps of time. But the Florida reality is the law emphasizes children having frequent and continuing contact with both parents. There's no automatic preference for mom or dad. Courts decide based on the best interest of the child, and they expect both parents to remain involved when it's safe. You'll hear time sharing instead of visitation. You'll hear parental responsibility instead of the old custody language. These words matter because they move the focus from winning to sharing a life. Think of it like this. The court is designing your child's weekly life calendar, not crowning a victor. That calendar should reflect how your child lives now, school, activities, friendships, and how both parents can participate without chaos. Here's a 1-sentence exercise. Finish this line and write it down. Each week, I handle blank for my child. Fill it in with facts. School drop-offs, reading homework, allergy medication, speech therapy, soccer practices. That sentence is the spine of your story. And we're about to put the muscle on it because that's the biggest part of what courts actually measure. If you've been a daily parent, morning routines, homework, sports, doctors, your goal is to show that calmly and clearly. If you haven't been as involved, your goal is to increase involvement now in a meaningful way and document it. The court is forward-looking. It wants to see a plan that works tomorrow, not a trophy for yesterday. Step 2, show up and document. Care beats claims. Judges weigh what you do more than what you say. So here's a simple low-stress evidence plan you can start today. 1. A care log. Make a one-page monthly log. Each entry takes 1 minute. Date, event, what you did, child impact, next step. Example. March 5th, pediatrician, strep swab was negative, gave meds at 8 p.m., follow up in 2 weeks. March 7th, homework, fractions finished, emailed teacher about extra practice. March 9th, soccer, practice and shin guards replace, game on Saturday. Number 2, neutral proof. Save neutral items. The after visit summary from the pediatrician, the email confirming a teacher conference, the team roster with your name listed as a contact. You're not building a scrapbook of conflict. You're building a record of care, and keep those files tidy and credible. Something like year, month, date, topic, and child initials. Number 3, keep a clean communication record. Move important logistics to a co-parenting app or email thread that's easy to export. Keep each message short and child-focused. Answer questions, propose plans, confirm decisions. Think about last week. What did you do for your child that nobody saw? Pack lunches, check homework, drive to practice. Write it down. Why this works. When a judge has to choose between a parent waving a stack of accusations and a parent showing a quiet pattern of participation, the quiet pattern carries weight. You're giving the court something solid to trust. Ask yourself, if a stranger read my log and messages, would they see a parent present in school, health, and activities? If yes, you're pointing the court towards the outcome you want. Meaningful time sharing that reflects your real life with your child. Now you have a system that works in your favor. Step 3, design a child-first schedule. Schools are neutral, bell times are predictable. Use both. Design your plan around school to stabilize the week and reduce opportunities for conflict. Start with this template and adjust to your reality. One parent drops off in the morning, the other parent picks up after school. Rotate which days belong to which home in a way that keeps school nights calm and bedtimes consistent. You can open your child's school calendar and map the next several weeks. Regular days, early releases, teacher work days, holidays, and testing days. Make the exchanges on campus when possible. Why? Doorstep exchanges are where tempers flare and little ears absorb adult pain. Campus exchanges feel normal and safe. You can also build in micro agreements that prevent friction, like response for logistics. We respond to schedule changes or requests within 24 hours on school nights and 48 hours on weekends. Confirmation rule. Major changes are confirmed in the app by 6 p.m. the day prior. Makeup time. If time is missed for reasons beyond control, we schedule makeup time within 30 days. Here's a real question to consider. Can your child explain next week's plan without hesitation? If not, the routine needs work. Holidays and breaks should be decided up front. Alternate or split in a way that feels fair and child-friendly. For long weekends or summers, keep the rhythm the child already knows. If baseball is every Saturday morning, choose a plan that doesn't force your child to decide between seeing a parent or playing on the team. And a child-first schedule has 3 qualities. It's predictable enough to lower anxiety, it's balanced enough to keep both bonds strong, and it's practical enough to live with for more than a few weeks. If you can say, my child can tell you where they'll sleep every night next week, you're doing it right. Step 4, protect the bond. Children have the right to love both parents, and courts notice which parents protect that right. That means you don't need to withhold time unless there's a true safety issue and a legal basis to do so. It means you don't badmouth the other parent to the child. It means you correct the record calmly when a child repeats something untrue without attacking the other parent. If your co-parent misses time or won't cooperate, use a simple escalation ladder that keeps the focus on the child. Step 1, document. Log the missed exchange or the issue in your care log. Keep it factual, date, what happened, impact on the child. Step 2, use a boundary script. Use this structure in your app or email. Fact, You arrived at 7:15. Pickup was scheduled for 6. Child impact. Alex was exhausted for school today. Ask or confirm. Please confirm on-time pickup at 6 this Friday, or propose a plan we can both rely on. Step 3. Talk to your attorney. If the pattern continues, ask your attorney to send a brief, neutral letter attaching your documented instances and requesting compliance. Often, the reminder that a court can enforce the order resets behavior. Step 4. File a motion. If the issue persists and harms your child's routine and well-being, you can seek court intervention. The point isn't to win an argument, it's to restore your child's stability. Now, when it comes to relocations, a parent can't simply move far away with a child on a whim. Moving 50 miles or more generally requires consent or a court order. If relocation is on the table, there's a process. Don't panic, don't lash out, gather facts, and get legal advice. Reasonable people and courts focus on the child's schooling, community ties, and continuity first. But the real question is, what pattern are you showing this week? Are you the problem solver or the problem creator? Remember this guiding principle. Judges notice patterns, not moments. Time and again, the parent who consistently supports the child's bond with the other home and documents their own steady involvement comes across as the safer, more child-centered choice when close calls are made. Step 5. Use clear communication and apps. How you communicate can either build your case or chip it away. Messages are often read by third parties. Write like that's true, because it might be. Use this 3-sentence message whenever possible. Fact, ask, next step. Fact, the game was moved to 6:30. Ask, can you pick up at 5:45? Next step. If not, I'll arrange Aunt Rosa and confirm by 3. You can also use co-parenting apps for logistics. The timestamps and shared calendars reduce misunderstandings, and the exportable record is there if needed. Keep each message under a few lines. Use names, times, locations. Avoid adjectives and accusations. When you're tempted to vent, don't type. Call a friend, talk to a therapist, take a walk. Then come back and send the calm message that moves your child's life forward. Here's one more tool I teach clients. The 3-sentence report for problems that keep repeating. Sentence 1, what happened? Sentence 2, why it matters for the child in 1 line. Sentence 3, what you're asking for. Be specific and reasonable. Try this right now. Think of your biggest co-parenting frustration in the last few weeks. Can you describe it in 3 sentences without using the words always, never, or ridiculous? This structure turns spiraling into decisions. Decisions turn into patterns. Patterns are what courts trust. And now you have a framework that works under pressure. Now, here are some questions that I get asked a lot. What if I work long hours or travel for work? Be honest and proactive. Propose a schedule that uses the time you do have well and build in makeup time. If you're gone Mondays and Tuesdays, lean into midweek dinners, school events, and strong weekends. Show how you'll remain a daily presence. Base time at bedtime, homework checks, Saturday sports. It's not about perfection. It's about reliability and love. What if my child is very young or still nursing? Time sharing for infants and toddlers can be adjusted for developmental needs while still building the bond. Short, frequent contacts can be better than long gaps. The goal remains the same. Regular loving time with both parents, scaled to the child's stage. What if my co-parent badmouths me or blocks communications? Don't retaliate. Document. Use a 3-sentence report. If it persists, involve your lawyer. Courts take interference seriously, particularly when it harms the child's relationship with a loving parent. What if there's a safety concern? If there's domestic violence, coercive control, substance abuse, or a credible safety risk, talk to your lawyer immediately. Safety comes first, and there are protective tools the court can put in place. Everything in this episode assumes a baseline of safety. Now, Let's wrap this up with a clear recap of the plan. Step 1, myths versus Florida reality. Florida emphasizes kids having both parents when it's safe. So learn the language of time sharing and parental responsibility. No custody. Step 2, show up and document. Keep a simple care log, collect neutral proof, and maintain a clean communication record. Documented care beats baseless claims. Step 3, design a child-first schedule. Anchor to school. Build microagreements. Decide holidays upfront and choose campus exchanges when possible. Predictability calms kids. Step 4, protect the relationship. Don't interfere. Use the escalation ladder. Document, boundary script, attorney letter, motion if needed. Know the basics on relocation. Step 5, use clear communication and apps. Write fact, ask, next step. Use a co-parenting app. Keep it short, clear, and child-focused. You do not have to choose between peace and protection. You can be calm and firm at the same time. That balance is what helps your child, and it often helps your case. If you want help writing the kinds of messages that reduce conflict and build credibility, download my free co-parenting communication checklist. Inside, you'll find quick do-don'ts, copy-ready phrases that follow the fact, ask, next step, the 3-sentence report, and sample microagreements you can paste into your plan. Parents tell me it turns a 5-minute panic into a 30-second plan. The link is in the description, so grab it before your next message. And if you'd like a Florida-specific plan for your family, something that reflects your work schedule, your child's needs, and your co-parenting reality, my team at Annette Sanchez Law can help. We build child-first parenting plans, set up communication systems that actually work, and guide you step by step with calm, practical counsel. In my next video, we'll tackle one of the hardest moments of all: how to tell your children about the divorce. I'll give you the exact structure, words, and timing that reduce shock and protect trust, so you don't have to guess on the most tender conversation you'll have this year. In the meantime, I'm Annette Sanchez. Thank you for caring enough to prepare. Remember, your child needs your love, your steady presence, and your calm leadership. With the right plan, you won't lose your child. You'll lead them through this.